on the fund.
Yes, they are gonna, the patient compensation fund starting 2027 will never pay a dime for a hospital claim. And in exchange for that, the hospitals have coverage for all of the people under their roof now. That was a change, not a clarification. And in exchange for a much higher cap that makes a lot more sense for a giant corporation like a hospital than the $600,000 cap, which was really intended for very, very narrow circumstances as specified in the Act. So we do think that Baker versus Hedstrom, although it was addressing a different set of circumstances, acknowledged what we're asking the court to acknowledge here, which is in order to cover the acts is what you look at. It's the individual's acts, and the individual has to be identified in the statute in order to be covered. So for all those reasons, we ask the court to find that this is not an absurd result. The hospitals get plenty of benefits from the act for their own direct negligence, and we ask the court to affirm the district court's decision.
Thank you, counsel. Any other questions? All right, thank you. 5 minutes for rebuttal.
May it please the court. I want to harken back to what Justice V. Hill asked earlier, which is, for all intents and purposes, what the plaintiff is arguing here is that Lovelace is not a QHP. That's the effect of their argument. Because to in the one hand say, it's undisputed that Lovelace is a QHP, but then to say, but they're not covered under the Medical Malpractice Act for the types of claims that are at issue here, what they're really saying is that it's not entitled to the benefits of the Medical Malpractice Act. This would be the first decision that I'm aware of issued by this court in relation to the Medical Malpractice Act, where the court is not applying language that is clear. There are certainly instances, Wilshinsky and Baker being 2 of them, where looking at the language of the statute, this court rightly recognized that there are ambiguities at different parts of the MMA. There's no ambiguity in this case. And so this would be the first instance where, despite the plain language of the definition of malpractice claim, the court would be giving it a different spin. I want to also briefly note this notion that the MMA is to be strictly construed. I hearken back to this court's decision in Wilshinsky, where at paragraph 25 of that decision, this court said, quote, "The legislature foresaw and intended broad application of the concept of a malpractice claim." And it did so because for every rule of statutory construction, there's another rule of statutory construction. And here, the one that I would ask for the court to consider is in Albuquerque Hilton Inn versus Haley. This is 1977 NMSC 051. This court said at paragraph 7, quote, "Where a statute is both remedial and in derogation of the common law, it is usual to construe strictly the question of whether it does modify the common law, but its application should be liberally construed." In Ledger versus Ledger, this is a decision from this court in 2022, at paragraph 47, footnote number 3, this court said the following: "According to one survey, states and territories passed remedial legislation in a 2-year period beginning in 1975 and ending in 1976. Yet only 5 codified non-assignability provisions, and it lists Mexico as being amongst those 5 states. This is remedial legislation."
What about the argument that this would open the floodgates to depleting the fund?
Senior Justice V. Hill, that's a funding question. That's not a statutory construction question. This court is called upon to apply, to interpret the law. That is what is before the court. The other point that I would commend to this court, as you have admonished all parties and all persons, which is that the court is going to apply a statute in a way that fulfills its purpose. The purpose of the medical malpractice would be disserved if it were not to apply in situations like this.
Which arguably are really narrow at this point.
They are, Justice Bacon, but one has to remember that the recently amended MMA talks about when injuries occur. And because there have been various cases in the last couple of years that have watered down the statute of repose in the MMA. You know, it used to be that only minors or incapacitated persons would be able to bring their claims at the age of majority, but that has since been expanded to include loss of consortium claims and things of that nature. And so courts are going to continue to be called upon to apply the MMA. And so the decision that you...
This version of the MMA.
Yes, Justice Bacon. So this is a very important decision that you're being asked to decide. I see that my time is very short. If there are any other questions that the court has of me, I'll try to do my best to answer them.
Other questions? Thank you, Mr. Montano.
Thank
I want to thank both the petitioner and the respondent in this case for their excellent briefing and oral argument in this matter. It'll be taken under advisement, and the case will be deemed submitted. The court is in recess until this afternoon.